Well, good morning, and thank you for joining us on the second of the construction and engineering teams events arranged by Zoom. This morning, the format will be a presentation from two of our members on aluminium cladding and other construction challenges, with the theme of getting our house in order. Those two presenters are Nick Kaplan and Phil Bambagiotti. The slides that are going to be used by Nick will be circulated after this presentation, so you'll get a copy of those. And the paper that Phil has put together is also going to be circulated to each of you after the presentation, so you will have that information for you. We hope to have time at the end for as many questions as we can. We've had some in advance, but we are hoping that the Q&A function, if you have a look at your screen about there, you'll see there's a Q&A button. If you press that, you can type your questions in. We'll try and field them as best we can and deal with those that we can. A short word before moving into the presentations about our team at 3 Paper Buildings. We've had construction specialists here since the 60s, and we remain a set where you can find experienced specialist counsel and decision makers at each level, many of whom have had experience of practicing the construction professions. All of us are interested in this topic. It's probably the biggest topic in our market at the moment. And indeed, it seems in some respects fitting that we should be posting it through Zoom, and therefore we're all in our own homes. So our first speaker is Nick Kaplan. Nick is a homegrown 3PB barrister, albeit he did work for one of the most effective teams in construction litigation before joining us. He's got some great cases that he's been working on, and I've learned that the phrase "you get pushed up the ladder" actually does mean something. So Nick's part of the presentation this morning will be the regulatory framework in England and Wales. I'm going to hand over to Nick now.
Morning, everyone. Thank you for that introduction, James. I'm just going to share my screen. There we go. Yeah, so hopefully you should all be able to see that, which is first the slides. So I am talking this morning about the legal framework specifically in relation to cladding and fire safety, which will hopefully be something of a framework for the discussion that is to follow for the rest of this morning. So just to summarise what we will be discussing, I'm going to go at a pace through the health and safety legislation, that's the Health and Safety at Work Act, and the construction design management regulations. Then I'm going to look at the building regulations as they touch upon fire safety requirements, and then turning to the various routes to compliance with what the regulations require, and then having a very brief look at some of the guidance that's applicable to cladding. Now, I should say that the legal framework is really a dense thicket of statute, regulations, guidance documents, and technical standards, and time will not permit me to go into any detail in relation to any of those things. But I will touch upon them in the highest level terms, and then hopefully some more will emerge from the discussion that follows. So starting with the Health and Safety at Work Act, which is a piece of legislation from 1974, and therefore should be relatively well embedded, both in our minds and in the legal system. So the Act sets out an obligation on all employers to, the wording of the legislation is, ensure the health and safety of those affected by their undertakings, which essentially means their businesses. And those regulations, that Act gives those obligations via sections 2.1, which sets out an obligation in relation to employees of companies or employers, and then at section 3.1 to anyone else reasonably affected by the business. And that is an obligation in each case to ensure the health and safety of those people to the extent reasonably practicable. So the requirement, as I say, is to do everything reasonably practicable. And because of the use of the word ensure in the legislation, what it effectively incorporates is a reverse burden of proof. That's to say, insofar as a health and safety incident occurs, that's a prima facie case that obviously you haven't ensured their health and safety, and it then falls to the employer to prove that they have done everything reasonably practicable. And that is an important difference to not only what one would usually expect of common law, but this is a piece of legislation with criminal consequences, and therefore it's highly unusual to have that reverse burden of proof there. So what does reasonably practicable mean? That's not something that's actually defined in the legislation, but there is pre-existing case law before the Act came in, which gives a sense of the meaning of the term. And the leading case in that regard is Edwards and National Coal Board, which makes clear that doing everything reasonably practicable is not the same as having to do everything that is physically possible to ensure health and safety. What the legislation requires is a balancing exercise. So on the one hand, you take the risk, making an assessment, both of its likelihood and its seriousness if it were to occur, and you weigh that against the costs of mitigating or avoiding that risk. And it's only where the risk becomes insignificant relative to the cost required to mitigate or avoid it that the duty is considered discharged. Now, we come to enforcement of health and safety law, and that is primarily something carried out by the Health and Safety Executive. And this character that you see on the right of the screen from South Park is what firmly comes to my mind whenever I think of the Health and Safety Executive. That is Captain Hindsight and his three sidekicks, shoulda, coulda, and woulda. It is, as I alluded to earlier, a criminal offence to breach health and safety law, and you can be convicted either on summary conviction in the magistrate's court, where you can have an unlimited fine, or a up to 6 months custodial sentence, or indictment, i.e. in the Crown Court. Again, the penalty is an unlimited fine and potentially up to 2 years in prison for anyone, specifically any specific individual found responsible for a serious breach of health and safety. So turning now to the Construction, Design and Management Regulations 2015, these replaced the 2007 regulations, and really the major differences there are firstly that the regulations now apply to all construction projects, including domestic construction, and importantly they shifted the focus of the legislation somewhat to give a greater emphasis on the design process, which is obviously highly relevant in the cladding context. And what the CDM regulations do is impose the regulations to ensure health and safety that we've discussed in relation to the Health and Safety at Work Act, specifically in a construction context, and impose those obligations on clients, i.e. employers or developers, contractors and principal contractors, designers and principal designers. And it ensures that the issue of health and safety is at front and centre of everyone's mind throughout the whole course of both the design and construction works. And those duties are to protect anyone affected by the works, which is both during the period of the works, i.e. people carrying out the works, but also anyone that could be affected by the finished building. So people living in it, guests making use of it, and anyone who works in it. So turning now to the building regulations, which is the main focus of this morning's seminar, and the main regulation in relation to fire safety will be Regulation 4 that we're going to discuss, which sets out what are known as the functional requirements that buildings in England and Wales are required to meet. Regulation 4 applies to any new build construction and to any extension and alteration works. It's important to understand that the regulations have had various iterations in the past. We are now under the 2010 regulations, but there are various historic regulations, and which set of regulations apply depends on when the building works were done, and specifically when the initial notice was given to building control in respect of those works. So it's measured from that date, and it's the regulations that were in force at the date the initial notice was given that apply to any new build construction. But for the purposes of this morning, I will be focusing on the 2010 regulations currently in force. So turning to the functional requirements, as I say, these are set out in Schedule 1, and it's Part B of Schedule 1 that sets out the fire safety requirements. I've listed all of them there. Those are not a summary at all. That is literally the wording of the legislation. It is very brief and very high level, and that is quite deliberate. The purpose of the legislation is not to set out technically complex requirements or even a specific means by which they are to be complied with. What they do is they set out some broad objectives that those working in construction are required to meet, and they're intended to allow flexibility as to the way in which those objectives are attained, so that we can preserve innovation in the industry. Now, for the purpose of this morning, it's really only the underlined requirement that's listed there that is relevant. That is the cladding related requirement, and it's that external walls resist the spread of fire over the building or between buildings. As I say, the functional requirements are intended to allow a measure of flexibility, and therefore there are various what are regarded as recognised routes to compliance with them. The main route that is most typically used and is therefore known as the linear route involves complying with approved guidance published by the relevant Secretary of State. That's set out in relation to fire safety in what's known as approved document B, for which there are differences as between England and Wales. There is also what's known as the performance route. That is a route using test criteria set out by the Building Research Establishment in their report BR 135. And then there is thirdly what is known as the engineering solution, which involves making use of a suitably qualified engineer with some fire safety experience to design an overall design that complies with the broad requirement to ensure health and safety and discharge the functional requirements overall on balance in the regulations. And really what that allows is that if you're not following the specific provisions of the approved guidance in certain respects, if one has inadequately designed measures that compensate for not meeting certain aspects of it, then as long as the building as a whole complies and has been suitably designed, that is regarded or can be regarded as acceptable. So turning to the cladding provisions in approved document B. Now I've listed here two relevant extracts. These are from different versions of the approved document. So at paragraph 12.7 of the approved document B that was in force at the time that the recladding works were done to the Grenfell Tower, the requirement is, as I've set out there, that in a building with a story 18 metres or more above ground level, any insulation product, filler material used in the external wall construction should be, in the wording of the legislation, of the guidance, of limited combustibility. That has since Grenfell been amended to some extent, albeit, as I'll come on to discuss, there's in my view, no huge difference, and that the materials used in Grenfell would have fallen within either of the categories, either as they were at 12.7 or as they are now at 10.6 of the current guidance. So that the current guidance provides that any insulation product, filler material, etc., used in the construction of an external wall should be of what is known as a performance class A2-S3 or D2 or better. So what that's setting out there is a minimum standard that all buildings over 18 metres in height must comply with. I should say that the government is actively considering at the moment lowering the 18-metre requirement to an 11-metre requirement. So these requirements would apply to all buildings over 11 metres in height. Now, what does limited combustibility mean, and what are the performance classes? So limited combustibility is defined at Appendix A to the older versions of approved document B, and it's a highly technical definition, but the essence of it is that the material should not flame under certain test conditions, and those test conditions are then set out in various technical documents, both European and British standards. That, as I say, has now changed to a definition by reference to a performance class. And there are three relevant things to consider in relation to performance classes. The first is defined as performance classes A to F, A being the highest standard, F being the lowest standard. And those relate to the extent to which a material either contributes to or hinders the spread of fire. There is then an S class. The S class relates to the extent to which, if the material is burning, it produces smoke. And then there is a D class, which is the tendency of materials when burning to cause fire droplets. And as I say, those are all specified in various highly technical documents that I barely understand myself, which set out various technical specifications and tests that these materials have to meet before they can be classed in any particular way. So that is all from me for now. I will hand back over to James.
That's the sort of seamless transition for which the BBC is known for. Nick, thanks very much for that part of the presentation. It's also an opportunity for me to say we've had a few questions come in. Thank you for those. We're not logging those. One of the unusual things about this format is we can't see you. So most seminars, we know who is in the audience, and that always helps. So when we get our questions, if you'd like to take the anonymous off it so we know who's asking the questions, that would be pleasant. So we're moving on to our second speaker now. Our second speaker is Mr. Philip Bambagiotti, who's been with 3 Paper Buildings for almost 12 months after completing his pupillage. But that's not really the beginning of Phil's story, because Phil's been a practicing lawyer for 20 odd years, having become a solicitor in 1992. And he's practiced in the very highest level of courts in Australia and Southeast Asia as well, and has a very strong practice in arbitration in Hong Kong. Indeed, Philip is part of a crop of new construction talent that we've got in 3PB, fresh talent, of course, like Rowan Planterose and David Parrott QC. So as part of that new generation, you can ask us questions at the end that maybe go beyond the domestic and possibly go into international practice as well. So with that in mind, I'm going to hand over to Phil, and I'm going to switch my screen off again.
I'm told that the, am I on? Yep. I'm told that the traditional greeting that English people understand as hello possums, but I won't use that greeting. I'll just say good morning from Sydney, Australia, part of 3PB Around the World presentation. Now, Nick told us about the regulatory framework that has cropped up, particularly around the response to the Grenfell Tower fight. But I'm going to be looking at a slightly different perspective. We'll be looking at the issues involved with what you can do and who you can sue in the event that you find yourself with a building that's burdened by ACP cladding. The fire at London's Grenfell Tower sent shockwaves around the world. The human tragedy and shocking images were bad enough. But a further factor that has led to ongoing concern and anxiety has been the involvement of aluminium compressed panel cladding, or ACP cladding, which was used on the facade. The reason that that has caused a particular concern was that at the time that it was used, it was thought of as a wonder product. It was a marvellous product that simultaneously dealt with a number of issues. Apart from aesthetic presentation and waterproofing, it was also used for thermal insulation and, of course, for acoustic insulation. It was cheap and convenient, and as a result, it came to be used almost everywhere. So that once the danger it posed to life and safety emerged with the Grenfell fire, the concern was even greater when we realised how much of this product was in use all around Britain and all around the world. The finding that such a new, arguably wonder product had this fatal deficiency also led to concern about the whole system. Now, the immediate response of governments around the world with that fire was to introduce a raft of building regulations. An example will be the New South Wales Building Products Safety Act, which shows that even on literally the other side of the world, the Grenfell fire led to a particular reaction. That act was designed specifically to limit the use of ACP, but it didn't limit itself to that use. Variations of the theme occurred in most countries, and the response was an easy and clear one. The authorities wanted the public to see that there was a problem and it was solved with a regulation, and one of the regulations of the nature that Nick was talking about. Sadly, however, the fire at Grenfell Tower followed a disturbing number of high-rise tower fires associated with ACP cladding. These included the 2014 fire at La Crosse Tower in central Melbourne, and as well as 9 blazes in the UAE up to New Year's Eve 2015. More sadly, after Grenfell, there were a number of almost identical high-rise fire events that occurred around the world, including the Torch Tower blaze in Dubai in August 2017, a matter of weeks after Grenfell. Since then, thousands of hours and billions of pounds have been spent around the world trying to inquire, analyse, inspect and investigate and speculate as to how this tragedy happened. But for we as lawyers and for those in the property development, construction and investment industry, there's a more pertinent question, and that is not how, but why it happened. At a very general level, the effectiveness of the laws can be reduced to one principle, and that is the extent to which the operation of building law and regulation aligns the economic consequences of risk-taking with the economic ability to control that risk. In a nutshell, whenever you find a dissonance between those two, you find a difficulty and a less effectiveness of a law. Whenever you can align the two, the law becomes much more effective because, in a sense, it's self-regulating. Up to 2017, our built environment came to be developed and managed by a broad and complex legal system, not only regulation. There were rules and regulations and statutes and pronouncements and proclamations and various laws governing those issues. But it also sat within the context of the common law, equity or chancery, as well as a statutory framework. To an extent, the law is so complex in the area that it fills libraries. So then we ask, as the public asked, What went wrong? And how did it go so wrong? And what can we learn from it? Partly it's the way that the law is taught. We are encouraged to look at the law as a bundle of distinct components: tax law, contract law, tort, crime, etc. And with each of those common law components, we have yet further refinements. Add to that the principles of equity or chancery, and then add the volume of statute, which has been increasing each year since the middle of last millennium, and seems to be increasing at an ever-increasing rate each year since. On a building site, however, the law doesn't come in neat bundles of legal rules and principles. In practice, the law comes in packs. It's necessary for people who are on site to negotiate a wide range of rules and principles, all of which seem to operate simultaneously. And many of these operate inconsistently. In practice, it's the net effect of the legal environment which actually produces its outcomes. To that extent, Australian law, just as the law in Britain, are similar in that they focus very heavily on contract law in the context of construction, with a range of other legal principles, but particularly statutes or regulations. But contracts are not always the answer. In purely common law terms, apart from the law of contract, there is a limited role for some other principles, such as tort for negligence, the law of restitution, and some equitable principles. Statute law in Britain includes a wide range of instruments that have a greater or lesser degree of generality. Examples are the Building Act, the associated building regulations, and other statutory vehicles such as industrial relations, occupational health and safety, the EU's Construction Project Directive, and the Supply of Goods and Services Acts. There is also specific legislation, such as the Defective Premises Act of 1972, the Unfair Contract Terms Act, the Unfair Terms in Consumer Contract Regulations, the Consumer Protection Act, and so on and so forth, and even the Misrepresentation Act of 1967, which I'll come back to. With this tsunami of legislation, all the Queen's horses and all the Queen's men and women did not prevent the ACP from being used all over Britain, and did not stop the fires and other tragedy that arose. This is why the why question is so important for us. And this is where the Danish King of England, King Canute, comes into the picture. The modern view of King Canute is that in setting his throne at the edge of the seaside and then commanding the tide to go back, only while it kept coming in to wet his feet, was neither foolish nor arrogant. The modern view is that he was making a point to his courtiers about the limits of royal power. The government's immediate go-to solution for the ACP crisis was to enact more legislation and more quickly. However, it's obvious that faced with the grim reality of a high-rise fire, the regulations and certificates are not going to be much use. More regulation is a popular answer from government because it's the simplest, tangible, and easiest way to show the public that something is being done. The problem is that there is a tendency for us in the 21st century to rely too heavily on the legislative response. Legislation or regulation suffers the fatal assumption that what it says actually matters in the real world. And unfortunately, there are only limited groups, including almost all politicians, that hold that view. Governments and oppositions accept the premise because the exercise of power by the regulation is their stock in trade. Believing that it matters reinforces their sense of might, majesty, and self-importance. But they don't always make that link between effectively managing, changing and evolving the behaviour of people in the community. Apart from instances where legislation does not change behaviour and is seen as ineffective, there are already many statutory and legislative provisions that adding more and more is like putting a Band-Aid upon a Band-Aid. I hope you understand what a Band-Aid is. And you end up with a mound of bandages, but these do not necessarily heal the wound. One of the ways that the shortcomings in the legislation and the common law contract framework has been to explore alternatives for other causes of action and ways of aligning responsibility and risk. One of the ways that has been used for the last 50 years has been tort law, which doesn't depend upon the existence of a contract and so can operate above and beyond it. For years, attempts have been made to deal with latent defects in buildings using tort claims, not only against builders, but also developers, architects, engineers, building certifiers, local councils, material suppliers, and the like. And that list doesn't mean that the remedy is, or the interest in the remedy is limited to the consumers who live in these buildings. They're also available to the developers, bankers, and others who are involved in the process. Now, why is it so difficult? Well, latent defects by their very nature are problematic in regulating building work in practical terms. It's difficult for the law of contract because by definition, one doesn't know where a latent defect is until it manifests, and that usually is many years later and very often after the building has been sold, and sometimes sold in multiple cases, and the responsible parties are difficult to track down. In many cases, the building legislation itself, even though it's framed in such wonderful terms, is of very limited assistance, with the majority of problems in latent defects lying outside of the statutory provisions. A good example of this is the Misrepresentation Act in Britain, which plays a far more limited scope and role than the equivalent misrepresentation legislation in Australia's Trade Practices Act or Australian consumer law, which is used in virtually every building case. As mentioned above, for years, we've attempted to overcome the limitations in the law with the use of tort claims for negligence, without any startling success. The common law has an aversion to recognising tort duties of care and negligence for claims for economic loss. And the law has developed around those claims in such a complex and uncertain fashion, it's difficult even to advise a client, much less comfortably commence proceedings in superior court. The curiosity, however, is that the same behaviour involves the law having no difficulty of imposing the same duty of care with respect to its breaches if somebody is injured. So if a builder's negligence causes a wall to fall and that wall injures someone, the law accepts without question that the builder owed a duty of care in building the wall for the purposes of the personal injury claim, but for some reason finds it impossible to recognise that such a duty of care occurred with respect to the collapse of the wall itself. Superior courts have wrestled with this for years, with persistent returns to examine the principle since the 1970s with Dutton and Bognor Regis Council. This led to a dramatic tightening of principles in Murphy and Brentwood DC in 1991, after which many believed in the UK that this was a lost cause. And of course, Australia has followed a similar path, even though our tests for identifying a duty of care are different. Claims in negligence for economic loss for latent defects reached their high point in 1995 with the famous case of Bryan and Maloney, and then dwindled away until in October 2014, with Brookfield Multiplex against the owners of Strataplan 61288, the law was seen to be as closed in Australia as it was in the United Kingdom. However, the court recognised that there was still scope for development. The problem is that despite the court's certainty, and either the courts both in the United Kingdom and Australia, despite their certainty that the law did not and should not provide remedies of this sort, the disjunction between risk and responsibility on building sites has led to more and more serious problems with building defects. In purely economic terms, if the risk carries no consequence, then the economic cost involved in managing the risk is not justified, and there becomes a temptation, and even an overwhelming temptation, to cut corners. That is, because the risk doesn't have consequence, it's not dealt with as seriously, and pecuniary remedies and pecuniary enticements have a greater impact. And of course, as risks are not managed and as corners are cut, the scope for deficiency increases, and increases in seriousness. The effect of this has been to systematically shift to someone else, usually people who cannot practically control that risk, the consequences of shortcuts and the disincentive of management. So for nearly 50 years, the courts and the lawyers have spent hundreds of thousands of hours and millions and billions of pounds wrestling with this concept of economic loss tort. And nearly all of that effort over all of those years has been focused on one question: what is the duty of care? The irony is that that's the issue upon which almost every case is turned, and it's an entirely theoretical issue. It means that all that effort has been spent on examining duty of care in circumstances where virtually none of the effort has been directed to identifying what was actually done on the site, what was actually done with respect to the building, and how did the problem occur and how could it be avoided. It's a wasteful diversion of effort and energy, and it fits within the definition of economic waste. The building boom in New South Wales for the past 20 years has changed the skyline, but has led to a crisis in building defects. This reached its high point in Christmas Eve 2018, when cracks developed in a building in the Sydney Olympic Park. This led to the occupants having to spend Christmas Day living in their cars. A few months later, another building, Mascot Towers down towards Sydney Airport, developed structural cracking that also caused an evacuation. Unfortunately for them, the occupants of that building are still not allowed back these years later. Within the limits of the law of contract and the light of the very limited role of tort for negligence, it was the mass of consumers who bore the brunt of structural deficiencies in buildings, because they could not recover compensation from those that could have avoided the problems in the beginning by exercise of a simple duty of care, and one that they had to comply with in any event. Clearly there was a gap. And to fill it, the New South Wales Parliament did what had been hinted at since the 1970s. And for the first time in the world, has passed legislation to fill that gap. Part 4 of the Design and Building Professionals Act, which was passed in early June and given royal assent on the 10th of June, provides a simple formula. A person who carries out construction work has a duty to exercise reasonable care to avoid economic loss caused by those defects. In forming this formula, there was an inspiration, I must admit, from the Design Defective Premises Act, which used an overriding statutory obligation to give a remedy for defective building work outside of the scope of contract. The difference between the two is that whereas the Defective Premises Act provided statutory obligations, the Design and Building Professionals Act is specifically intended to pick up and utilise the common law, and that is the rich history of case law and statute law that surrounds such a well-known concept as tort in every area other than economic loss. Note that all that the statute does is to crystallise the existence of the duty of care. So in that one sentence, those 50 years of fruitless argument was swept away. The tort law for economic loss aligned with the tort law for personal injury. The content of the duty, however, remains to be determined according to common law, so it will automatically reflect the specific facts and circumstances of each case. The tort itself is kept within its bounds by the range of other statutory and other defences, limitations and constraints that the law provides to tort generally. The statute merely builds upon the established and recognised tort principle. Having said this, the existence of a duty is not in doubt, so the cost, expense and uncertainty are no longer a factor. The building claims for defective work can focus on the work rather than arguing textbook questions. Ironically, by removing the uncertainty and increasing the pool of potential defendants, including insured defendants, the pool becomes broader, and that makes claims more likely to settle in mediation, which lowers the overall community cost of building defect dispute litigation. And further, by shifting the responsibility so clearly to those that have the capacity to control the risk of defects, there becomes an inbuilt commercial incentive for all those that control risk to actually control it. They have a reward for doing their job, and that is they avoid the prospect of defects emerging later and suit emerging later. So to that extent, the system is self-regulating. It doesn't require a policing mechanism because it's the owners who would discover the defects and have the ability to enforce. More importantly, the very broad support for this legislative solution will give the legal community, including the courts, a reason to pause and more deeply consider their approach and the assumptions made with respect to economic loss tort. Are those assumptions really sound? Do they really reflect the understanding and expectations of the 21st century community? The degree to which the imposition by statute of a duty of care has been so well received may then ask the question whether or not, for the past 50 years, our approach to economic loss tort was the right one, and whether or not the solution could have been provided years ago and been provided at a time in which people were making decisions about aluminium cladding. So what does this Antipodean development mean for Britain? May I suggest a few things? It should stand as an encouragement not to simply take as read the received wisdom from the case law regarding construction issues, and including the use of ACP. Rather, there is both the opportunity and the incentive to test the boundaries, to push the envelope, and whatever other euphemism you want, to test the conventional limitations of areas of law that aren't the usual and well-trodden paths in the context of construction. These include tort, as well as restitution, as well as equity or chancery. But they also give rise to the question as to whether legislative reform is open to be encouraged, and whether the judicial interpretation of legislation we already have that is limited really is a justifiable interpretation today, or whether the court should be encouraged to be more adventurous with certain of the statutes. Finally, it shows that it's possible to formulate and stimulate a useful and non-ideological statutory reform that cuts through the weeds that Nick mentioned. and that would take otherwise years of common law consideration through the courts. The ACP is still a crisis, but rather than just sitting and hoping for legislature to come and save the day, the answer may well lie with us, the legal profession, supporting the industry specialists. And it may mean that what is called for is a more imaginative, active, and sometimes even novel and brave approach to the parameters of our current legal framework, with a view to ensure that the common law remains an active, modern, and living result and is proactive rather than simply reactive. Maybe that's something to think about, because with that, we can not only provide more long-term benefit for clients by aligning risk with responsibility, but more satisfaction for people who are in calamity of having an ACP cladding problem without an obvious route to solution. Thank you.
Spring back into life here and thank Phil for that presentation. Philip is far too modest to mention that the case that he was referring to, the Brookfield case, Brookfield in Multiplex, which went all the way up to the top of the shop in Australia, was one where he was counsel and he was also substantially involved in the lobbying to get the legislation through. So moving on to the discussion phase of our morning, thank you for the questions that we've had through, and thank you particularly where you've been giving some names. One of the questions was sort of a bit of an update, really. Where do we stand with the inquiry at the moment, the Grenfell Tower inquiry? I've got in my hand here a paper that was produced by Nick Kaplan and Philip Bambagiotti, interestingly enough, about the present state of that. Now, Nick, I was wondering if you could briefly summarise today's status, where we are now on that, and we'll move on to the detailed questions after that.
Yes, I'm sure everyone will be aware that phase one of the inquiry finished relatively recently, and the report, multi-volume, was released. That phase one dealt with in effect, the immediate causes of the fire and the incident on the day that it occurred, and reached some interesting conclusions and gave a good pointer as to where phase two is likely to go. I think for this morning's purposes, what clearly emerges from phase one is that Lord Justice Leveson already considers that the cladding on Grenfell did not comply with the regulation and the guidance as at the date that the recladding works were done. Phase two, which I believe started either this morning or yesterday, it was put on pause given the corona. It's getting back up to gear now, and that phase two is intended to look at the regulatory system and the design process and really look into fine-grained detail at quite what went wrong and how the cladding came to be recommended, and what improvements need to be made to the design process and the regulatory system to stop that happening again. Philip, I don't know if you've got anything you wanted to add to that.
Yes, having examined issues such as the facts that occurred on the ground, the role of the fire brigade, the role of the fire brigade systems. The phase one report ended with a very important but particularly overlooked observation, and that was that there was a view, without elaboration I should point out, that the use of the cladding in the Grenfell Tower building itself didn't comply with the regulatory framework that was in place at the time. And I mentioned at the time that was significant because the inquiry seemed to have left the door, I won't say open, but certainly ajar for the prospect of people who suffered personal and economic loss at the time to bring some claims for compensation and relief, And it also left the door open for people who were involved with buildings that were affected by cladding and who might be constricted or constrained in terms of who they could pursue for recovery, usually because the construction occurs years before companies dissolve, single purpose vehicles have spent and are eliminated, or people are just impossible to find, or evidence is impossible to find. So the inquiry suggested that there was going to be some reflection of the bases upon which claims can be made. But it was very limited and very tantalising. And I suspect that part of the reason for that was to utilise the self-interest of the community in bringing proceedings to explore these questions of liability, fault and risk. The next phase of the inquiry will involve a far more detailed and rigorous analysis of the regulatory framework. That is the building regulation part, and it'll be a critical analysis. That being said, there is nothing about that analysis that I've seen in the first report or in the early stages of the second phase of the inquiry that extends the inquiry very far into the general legal context or the legal environment in which the regulations occur. It seems as though there is going to be a focus upon how to make the regulations better, rather than, is this the right way to regulate? Or should the regulation be actually simplified and broadened in the manner that Nick identified with the high-level prescriptive requirements rather than the detailed minutiae? That'll be an interesting phase to see. They're going to spend a lot of time going through a lot of statutory regulation, which will be a first in this kind of inquiry.
So just coming back in on that, I'm hoping I'm unmute. The extent to which these regulatory changes and inquiries end up delivering practical changes is something that we've all taken an interest in. I often take a view that if it's not a part of a procurement solution and considered at the procurement stage, then the regulations don't really have any particular effect other than they're a bunch of things written in files kept on a wall somewhere. So we've had several questions that pick up on that. There's one coming from Gerald McLean. That one is as follows. 5 years ago, a panel would have met all the recommendations and have complied with the relevant building regulations. Now it would not. If it's necessary to remove the panel, for example, to remedy defects and cavities, is it permissible to reinstall it? That was from Gerald McLean. That also is quite similar to a question that we had in advance of the session as well. I'm going to start with Nick on that one. Nick, would you like to start with the answer to that one?
Yeah, I don't think there is any straightforward answer to that question. In my view, really, it's likely to come down to a question about whether, when one's putting the cladding back on, are you reinstating what was originally there, i.e. are you able to reuse the cladding that has been taken off, or are you, in effect, doing some recladding works? Insofar as what you're doing amounts to a recladding of the building, then it will have to be done in compliance with the regulations and the guidance applicable at the date on which you're putting it back on. If what you're doing is merely putting back up the cladding that was already there, i.e. reinstating after you've done some opening up works, it seems to me that need only comply with the standard applicable at the date that it was first installed X many years ago.
So, I mean, there's the point, isn't it? The regulations need to make sense, not just to sort of Archie and Harriet arguing about it in the House of Commons, but also to Mickey and the guys putting the panels actually up on site. We've taken them off. What do we do with them? Can we not just put them back on? It's the traditional way things would tend to have been done. But I've got a question for you that I'd like you to pick up on. It's from Sharon Taylor. The torch in Dubai caught fire twice. Who do you sue in that situation? The government for not amending or implementing the regulations, or the developer, even if they complied with the regulations?
The issue is in Dubai, good luck suing the government for anything. But just say this happened in Britain today. One of the reasons that I encouraged people to look at the range of alternative causes of action and alternative solutions is that you may find that between the first and second fire, you have a different cast of characters and a different range of activities that are involved. So, for example, there is one thing to design, specify and install ACP cladding. It's quite a different thing to allow it to remain after a fire has already torn through the building, or, as Nick was saying, to replace it. It may be that you end up with different people who have a different level of responsibility. And with each of those different people with different responsibilities, you end up with a new and potential defendant. In a lot of instances, for example, in the United States, government authorities can be sued because they fail to take responsible safety steps after a fire or after a risk has developed. That's not always and everywhere around the world, and this is why this problem of aligning risk and responsibility. But when you ask Sharon, who can you sue? The question is one that requires a very broad-minded approach as to responsibility and causes of action. And as I said, sometimes you've got to be a little bit more adventurous than other people are or have been traditionally. I hope that answers your question.
Another question that came in, what's the minimum a developer has to do where ACM cladding is in its building? I'm going to put that one over to Nick.
So I think this raises some interesting questions about both what happens in the short term and what happens in the long term. Obviously, if you've got ACM cladding, the suggestion I think now is that it all be removed and replaced, but that is not something that one can do immediately for obvious reasons. In the meantime, measures should be taken, I think, to ensure that that tenants are reasonably safe despite the absence of a safe cladding material on the external facade of the building. And things that I've seen being implemented for those purposes is having a full-time fire warden on site there to get people out in the event of an incident. Obviously, running a full risk assessment and identifying particular problems with people exiting the building and resolving those problems is sensible. And if you can install things like a sprinkler system, then that obviously is going to help considerably in the event of a fire. So it's installing interim measures like that until such time as one can get the cladding up to scratch.
Brilliant. I'm going to exercise a little bit of chairman's prerogative at this point in time.
Sorry, could I just very quickly say something on that?
You may, but what I'm going to do is I'm going to put a little bit of a division in here. We've had our hour. If people would like to stick around and enjoy the rest of the discussion, which I will keep going, and I'm going to let Phil come back on that answer, please do stay on the line. For those of you who've joined us for our appointed hour, we are very grateful. We've got 2 events coming up on Thursday, one for the employment team and one for the family team. So if you look on the website, you can log on for that. The next point is just to thank those involved in putting on the presentation, and we will continue with the discussion. So goodbye to those of you who are leaving. Phil, if you want to come back in, please do so. Thank you.
Part of the problem is that not all aluminium cladding, not all aluminium combustible panel cladding is combustible. Some panels, indeed, are safe to use at one stage of their life and can become dangerous and combustible over time in certain circumstances. Part of the problem has been that the answer isn't as easy as simply walking along and looking at every building with ACP cladding and saying that's all defective and that's all got to go. The problem is that it can sometimes take some effort and not so much, and involve even risk involving abseiling and the like, in order to identify which is the cladding that needs to go. And then you face the challenge that Nick pointed out of the cost of doing so. I've got a case at the moment where there is a building not far from Sydney that has ACP cladding, and the cost of removing it, and not all of it has to be removed, I should point out, but the cost of removing the bits that need to be, with the scaffolding and all of the rest of the responsibility, adds up to millions and millions of dollars. The challenge has been to find a solvent or insured defendant to get to pay for that.
I'm going to come in on that one as well, because this feeds into one of the questions that we've had from Orla Fitzgerald. Finding the solvent defendant, I'm paraphrasing her question, finding the solvent defendant in this jurisdiction often amounts to hitting the last professional standing with PII. I thought there was a link through to the legislative solution that you were discussing, or that you'd helped put in place in New South Wales, Phil.
Yes, and that's exactly it, because the legislation, because it's broad, and we have we've done away with unitary liability, so we have proportionate liability for tort, and so there is less of an encouragement for professionals to capitalise to the lowest level and then to wind up and turn over, because they've got a degree of protection. But what has happened, in fact, is that because there's less uncertainty, risk and cost involved in identifying whether there is an exposure, you get more people, particularly insurers and professionals, coming to the table at mediation and dealing with the reality of what happened, rather than haughtily just telling people to go off and sue them. And what that has meant is that with the bigger pool, the individual responsibility has reduced. So, for example, in a circumstance where the architect may have been the last person standing and carrying all of the risk, because you've got the scope for engineers and councils and certifiers and others, the risk, the risk and the contribution to reduce the risk is spread in a more wide and shallower way.
Sorry, Phil, are you saying that the money that gets spent by the insured, which goes into the pool, then goes actually to the people who suffer the damage and the loss, and not to the cost of fighting the claims?
That's right, and that's the whole idea of this legislation. It's actually designed to reduce building litigation.
So that presumably means it's working when there's less litigation or less contested work, yes, and there's more payouts?
Yes.
And so the money goes into investigation?
Yes, and the payouts will generally be less.
Because they're actually solving the actual problem rather than claims that have been developed, shall we say? Well,
put it this way: if there's a $200,000 claim,
yeah,
and you've got two defendants, or there's a $200,000 claim and you've got 10 defendants, it doesn't take much to see that the scope for spreading the risk over that wider pool of defendants will involve each defendant being exposed for a lesser amount.
We've had one of the first questions we had in this morning was from Emily, saying we're seeing an argument run that even if the requirements of approved document B are met, it is said that a wall build-up still does not meet the requirements of the building regulations, adequately resisting the spread of fire. What's your view on the aspects, I'll say, of this argument? It seems a question about balance, doesn't it, Nick?
Yeah, I mean, I think strictly speaking, mere compliance with the guidance in the improved documents does not necessarily entail discharge of the requirements in the regulations. It would be ultimately a matter for a judge to decide whether or not the regulatory requirements have been met, and complying with the guidance is very strong evidence of that. But it doesn't logically follow that just because I've done what the guidance says, the duty is fully discharged. So there is scope for a finding that despite compliance with the approved document, nonetheless you remain in breach. But I think it would take a very bold judge to reach such a conclusion.
Another quick one for you, Nick, then. We have devolved legislatures in this jurisdiction, and there are distinctions emerging. What are the distinctions? Particularly the question from Martin Stevens was between England and Wales.
Yes, as you say, we have a devolved assembly in Wales. It has published its own guidance. I have to confess I've not read that in any great detail. As far as I understand, the only real current difference between that guidance and the guidance that's followed in England is that there is a specific requirement now in Wales that all new build construction of whatever level have sprinkler systems installed.
And to a certain extent, that's going to mean that's good. That is good, not just legislatively required, but that's going to be established as good practice in the wider jurisdiction.
Yeah.
So the follow-up question I would have is, if that's considered to be good practice, nearly over the bridge in Wales and Cardiff, why is it not also good practice in down the road from me in Chelmsford or up in Newcastle?
Well, it does raise an interesting question as to whether, if one complies with the English standard and not the Welsh standard, the English courts could say for an English contractor building a property in England that it's still not good enough because the Welsh standard is a higher standard, and that's the one you should be following. Again, I think it would take a bold judge to come to that conclusion.
We had a question about cross-laminate timber. But I think we reached the limits of our technical understanding, certainly I did, in answering that. So apologies if I can't answer that question for you. Let me see, I've got one more here, which was related to insurance principally. I think at this stage, we're very pleased that so many of you have chosen to join us for the discussion stage of this presentation. But I think it's appropriate to draw it to a close now. Thank you very much for coming with us. We've had some interesting guests on this sort of chat show that we've had to discuss this most serious issue of the day. We've had a visit from Captain Hindsight. King Canute made his entrance, and we also had a grandfather clock chiming too. We hope that you or your colleagues enjoy future events that we put on. And as the avalanche of attendees sort of starts to drop off, on behalf of 3PV, can I say thank you to the team who supported the event and to you for coming. Normally, we'd be saying, come and join us at this time of the day for a cup of coffee, but I'm looking forward to something a little stronger, all in due course. Thank you very much for coming.